proud unveiling for British ambassadors.
Sorry, here we just have our.
You? I think it's
Yeah, okay.
Oh, yeah, thanks.
Oh, good.
So all you Harmon Phelps folks, I know Kurt Karstrom.
I work directly for Kurt.
Do you?
I am supposed to be the mini Kurt.
He and I do the FDA boot camp together.
Oh, okay. So I do hatch waxman.
Sure.
So
Right,
I came
right,
from
that's what
fish
he-
and retrieval.
Oh,
My
okay.
background is I'm not a patent lawyer, but my background is kind of the intersection of patent and FDA.
That's great. Oh, Kurt's a great guy.
Yeah, he's really wonderful.
Okay, we'll get started. I think all the students are studying for finals. I see Eric here. That's two students. Thanks for coming. It's the last of the year in our series of PIJIP's Supreme Court series. And this year there have been a lot of cases. And so this is the ultimate day of the court in session, and the ultimate case that they heard. It's the case of Amgen versus Santos, and this is beyond complex. This is a really, really complex case for the court to have taken on the last day of the term. And I'll tell you why. I'll give you a couple of reasons. It involves not only the petition for cert, but a rarely granted cross petition by Amgen. It involves Obamacare. It involves multiple federal agencies. It touches on federal and state law. It involves an incredibly complex statutory scheme, which is the Biologic Price and Innovation Act. And it involves comparison to another incredibly complex statutory scheme, the Hatch-Waxman Act of the Patent Act. So with all that, the Supreme Court decided this was the last case they wanted to decide this year. It's almost like my 1L's ultimate nightmare. All the issues they hate involved in one case, except the rule against perpetuities was graciously left off the list. This case involves very complex technology. It involves regulating biosimilars. And biosimilars are, as they sound, similar to a manufactured drug. But unlike the typical drug you think of, Claritin has some generic competitors which make something very similar to Claritin, almost identical. Biosimilars, by their very nature, they're very large and they can't be created exactly the same drug. And so there's something called biosimilars that the FDA approves, and they have a very complex scheme which we'll talk about today. Basically, the scheme allows competitors to enter the market 12 years we'll talk about that too, after the drug has been manufactured and sold. So today we'll talk about three issues, the three issues in this case. The first one is this. Here's the language from the statute: shall provide to the research pharmaceutical company, it's Amgen in this case, a copy of the application submitted under subsection K. And the question is, does the word shall make disclosure mandatory, or, as the Federal Circuit held, optional? The second issue is shall provide notice to the research pharmaceutical company, again Amgen, not later than 180 days before the date of first commercial marketing of the biological product. The question here is whether that application can occur, or the notice can occur before the end of the 12-year period, or if essentially they get 12 years and 12 and a half years of exclusivity. Those 180 days make a big difference. If you're marketing a $1 billion drug, selling that for 180 days without competition is very, very valuable to the company. And so the third issue is a broader issue. It says, can a court enforce it should say, that's a typo, can court enforce the 180-day requirement by enjoining the marketing of the drug until notice is given. Essentially, Sandoz is arguing that a line of Supreme Court cases restricting the implied private rights of action should also restrict the equitable powers of the courts in this case. And so those are three very difficult, wonky issues that we'll hope to get to the bottom of. And so joining me today are four esteemed panelists, and I'll briefly introduce them, and hopefully they can introduce themselves more. To my right is Jennifer Thomas. She works for Hyman Phelps and McNamara. To her right is Sarah Koblitz. She also works for Hyman Phelps and McNamara. And to her right is Donald Ware. He's with the firm of Foley Hoag. And Michael Morin, he's with Latham and Watkins. And so I'll briefly have them explain what their role is as amici, or what side they came out on. And I think in the interest of time, we'll have them briefly talk about maybe one or two of the issues in this case before we start talking more specifically about specific issues in this case. Because there's so much here that if I had them explain everything they argued, it would take at least the hour we have today. So let me start with Jennifer, and we'll go from there.
Okay. Thanks for having us, and thanks for that introduction, Professor Anderson. I'm Jennifer Thomas, and I work for Hyman Phelps, and we represented several amici on a single amicus brief that was submitted in this case. The amici we represent are associations that then represent actors within the drug supply chain. They essentially are involved in the process of getting these treatments to patients. So we represented the National Association of Chain Drug Stores. They represent about 40,000 pharmacies in the United States that employ about 180,000 pharmacists. So the people that are sort of intimately involved in getting pharmaceutical products and biologics and biosimilars to the patients who need them to treat illnesses. And then we also represented the Pharmaceutical Care Management Association, and they represent pharmacy benefit managers who administered drug plans for millions of Americans. And then the third organization we represented on the amicus brief was the Healthcare Supply Chain Association. And they represent group purchasing organizations. And those are generally groups of hospitals, and generally nonprofit hospitals that are also non-governmental hospitals. And they basically harness the group purchasing power and negotiate with drug manufacturers to get deals on drug products, pharmaceutical products. So our role in this case was generally to bring to light to the Supreme Court's attention the interest of our clients and also of patients in speedy access to biosimilars, and the importance really of holding companies to the 12 months of exclusivity that was afforded under the Biosimilars Act here by Congress. So we were focused on, and I should just say that here today I'm speaking from my own views and not necessarily speaking from associations. If you ever represent an association, you'll understand why I need to say that. There's a lot of approval that goes in to these things. So we really spoke to only one of the issues presented here today. And my colleague Sarah will go into the details of issue 2 and our position on that regarding the notice of commercial marketing and requirements.
Thanks, Jen. Thanks, Professor Anderson. I'm Sarah Koblitz. I'm also at Hyman Phelps and McNamara. My practice focuses on Hatch-Waxman, which is very related to the Biosimilars Act and kind of what this whole issue is about. We, as Jen said, we focused more on the policy issue, and because of that, we were really narrowed to issue 2, which is the issue of notice and whether notice should be provided before licensure or after. We believe that it should be provided after, or I'm sorry, we do not speak for our clients, just to be clear.
Right, but our position.
Our position. Right.
Before. Right.
Our position is that that the licensure should come after, or can come after, notice. We looked at the statutory text, and we argued that the language of 262K, which is in part on the screen in front of you, but it also is it to be more exacting. It says any person may submit an application. No, that's the wrong part. Okay, well, I'm just going to come back to it. Anyway, we believe that the licensure after notice after licensure is not supported by the statutory text. The statutory text specifically refers to an applicant and requires an applicant to provide notice. And under an applicant licensed under subsection K identifies the product separate from the reference drug. If otherwise, we believe that the statute would have said that the application holder, or I'm sorry, the approval holder should have given the notice.
Right. Yeah, that's
And we also argued that Congress could have explicitly prohibited notice until licensure had occurred. So the language was not. If Congress could have made the language more explicit to limit licensure, limit notice to after licensure, should they have wanted to do so. We also made the argument that Part 1 of the patent dance, which is the submission of patent information from the exchange of patent information between the parties to determine if any patent infringement had occurred, should occur in Part 1. There are two stages of the patent dance under the biosimilar application process. We believe that the first part should have been the more meaty part of it, where most of the information is exchanged, while Part 2 should be the residual patents, things that weren't quite addressed, and that wouldn't need as much time to complete as the first part would. I will.
Okay.
I just kind of.
It's a nice, simple statute. So I'm Don Ware, and as Professor Anderson said, I'm a partner at Foley Hoag in Boston, and I mainly represent biotechnology companies and universities in patent disputes. I drafted the amicus brief of BIO being the Biotechnology Innovation Organization, formerly known as the Biotechnology Industry Organization, which is made up of, there are probably about 1,000 companies and universities who are members of BIO. So it's a complicated organization, and in fact, Amgen is a member of BIO, and so is Novartis, which is the parent company of Sandoz. And BIO is in an interesting position for this amicus brief because many of the members of BIO are intending to manufacture biosimilars as well as innovator biologics. BIO was extensively involved in the development of the legislation, as was I personally. I worked with BIO and a number of biotechnology companies and universities, and the legislation was sort of crafted and negotiated over a period of about 4 years from 2006 to 2010. And, I think the students here would be interested to know this is a very unusual process of developing legislation. It was essentially negotiated among stakeholders. And so you see very little legislative history. You don't see a Senate report, for example. The bill was crafted by the staff of the Senate Health, Education, Labor, and Pensions Committee. And the staff members would have representatives of both biotech companies, for example, and representatives of generics companies, who were companies that were interested in becoming biosimilar manufacturers, into Senator Kennedy's chambers, and we'd sit around a big conference table and debate all these provisions. So I sort of have a perspective that's a bit of a personal perspective from having been involved in the legislation. But I worked with Bio at the time, and so the position that Bio presented was very consistent with my own views. And very briefly on the two principal issues, the position argued by Sandoz was that the statutory procedure that is laid out for resolving patent disputes is optional, and that a biosimilar applicant can decide to invoke it or not. The Bio amicus brief disagrees with that position and takes the position that shall means shall, and that when a manufacturer chooses to follow the route of filing what we call a K application, which is somewhat equivalent to an ANDA in the Hatch-Waxman statute, in which the applicant is allowed to make use of the data, the clinical data of the sponsor, the originator, innovator product, that when they make the choice to rely on that data, they are making a choice that they will then comply with the statute and follow the statutory procedures for resolving patent disputes. So that's really the answer to question one. Another way that Bio's chief IP counsel and I have put it is that we didn't spend 4 years working on this legislation to create an optional procedure. And that position, I can tell you from personal experience, is what the chief staff counsel for Senator Kennedy's committee has said to me as well, that he didn't spend 4 years working on it for it to be an optional procedure. So we feel very strongly that the intention was that both sides, the applicant and the originator of the reference product, are both bound by this procedure as the means to resolve patent disputes. On the second principal issue, the 180-day notice, Bio has a somewhat nuanced position. I think that Professor Anderson put the question in terms of whether or not the notice has to be given before or after expiration of the 12 years. We wouldn't put it that way. Our view is that the notice needs to be given after the FDA has approved the product. Approval cannot be made effective prior to 12 years after the licensure of the innovator product, but that in our view, the FDA would be free to approve the product, in effect tentatively approve the product as happens in Hatch-Waxman prior to expiration of the 12 years. So prior to the time when the biosimilar applicant could actually launch the product, and make that approval effective upon the expiration of the 12 years. In that case, the notice could be given after approval, the second phase of litigation could proceed, the patents could be resolved prior to launch of the product, but that there always needs to be at least a 6-month period provided prior to commercial launch, so that remaining patents that haven't been litigated can be litigated and resolved. And so in Bio's view, the issue that arose in this case that Sandoz presented was really an artifact of the timing of their application, which is to say that in this particular case, they were seeking approval of a biosimilar where the reference product had already run through its 12 years of data exclusivity. And so as a consequence, under those circumstances, there still needed to be a 6-month period for the notice of commercial marketing. If, on the other hand, Sandoz had filed this application prior to the 12 years, prior to expiration of the 12 years, they could have sought FDA approval at that time, obtained the approval, given the notice of commercial marketing, which could have been 180 days prior to expiration of the 12 years, and litigated the patents before that 12-year period. So in our view, the statute doesn't automatically provide 12 and a half years of data exclusivity. It's just that in these particular circumstances, where the 12 years had already expired because of the requirement of a 6-month period for litigating the so-called phase 2 patents, that situation occurred here, but it will be less and less likely to occur in the future. So we urge the Supreme Court not to adopt an interpretation of the statute that arose really because of as we said, a kind of an artifact of timing. So, Mike?
Great.
So I'm Mike Moran. I'm a partner at Latham & Watkins, and we represented AbbVie in an amicus brief in this case, supporting Amgen's position, supporting the side of the innovative pharmaceutical company. I guess it sounds like we have you to blame for any potential ambiguities or complications in the statute, Don. But we read,
I did my best to remove them.
Yes,
Believe
yes,
me, they were already there.
I understand, and we likewise think it's clear that when Congress said that there's some quid pro quo going on here because the biosimilars statute, similar to what you had before and still have in Hatch-Waxman, allows the biosimilar company to take what's effectively a shortcut, and a big shortcut. They can piggyback off all the work that the innovative company did to bring the biologic product to market. And in our view, and there's smart people on both sides, but in our view, it clearly intended that as part of the quid pro quo for that, meaning as part of that piggybacking agreement that they can piggyback, the statute makes clear that they also need to fulfill their side of some things, which includes providing a copy of their application to the innovative company and going through what's been called the patent dance. It's an exchange process where you flesh out your patent disputes so that you can get to the point where you can have a well-reasoned and well-informed patent litigation. So on that first issue, we are on that side as well, on the innovative side, believing that the exchange process is mandatory and not optional. And so that's how we came in our amicus briefs. On the second issue, and we've really talked largely about two issues, there's a third that we'll get to. But on the second issue about when notice has to be given, we also agree that notice should be given after the product has been licensed by the FDA. Otherwise, the notice really means nothing. If someone could give a notice today or immediately upon even filing of an application. There's disagreement, by the way, between the amici on the side of the biosimilars is about whether you could give it right away, even before you file an application, whether you have to wait till there's an application filed, when you could do it. But our point is notice isn't really notice at all if it's so early that it doesn't have a concrete idea of when the product will be launched, and it doesn't really mean very much, and when the product could still change. And I think Seth Waxman did an excellent job today pointing out that the product can still change, the manufacturing processes can change, a lot of things can change before the licensure of the product. So we are in agreement that 180-day notice needs to be given after the licensure of the product. There's one other issue that we haven't really touched on as much today, which is a really important issue, which is why does it matter and what's the remedy? And a big point of dispute on both of those issues is the question of if someone doesn't follow the statute, what can the innovative company, what can the reference product sponsor, you'll hear it referred to, RPS, what can they do about it? And the argument from the other side, from Sandoz's side, excellent lawyer Dan Maynard presented for them today, but the argument from their side is you are limited to the remedies that are pointed out in the statute. And to make that, and those remedies are basically, I'm simplifying it, but basically that the reference product sponsor, the innovator, can file a patent suit if the other side, if the biosimilar company doesn't comply with its obligations. So goes the argument that if the biosimilar company doesn't provide the information that's required to under the patent dance, well, the only remedy for the patent holder is that they can file a lawsuit. And if the patent holder, if the biosimilar company doesn't provide 180 days notice, the only remedy there, they would say, is you can file a patent infringement suit. And in our view, that doesn't seem right. In our view, if the party doesn't give the information it's supposed to give, then that would put the innovator on the side at the beginning of the case of filing a suit with less information than it should have before it's in a position where it needs to sue. And on the notice side, it means there's no notice at all, because think about it. You've only failed to give 180 days notice by definition when the product launches, right? That's the only, you won't have failed to give adequate notice beforehand until the date comes that you launch, and it turns out that you didn't give that notice. But once you've launched your product, you can bring a lawsuit anyway. So saying you have the ability to bring a lawsuit is no remedy at all, and it renders the entire notice statute, in my mind, somewhat meaningless. So those were our positions. And then there was also a nuanced issue that I don't know how deep we want to get into the nuances, but there's an issue of whether it's even properly before the court in this case. And the reason for that is that Amgen brought this case in California originally, alleging only state law causes of actions. California has an interesting unfair competition law that says basically that it can be a state law violation to fail to follow another jurisdiction's law, which includes federal law. So it's an interesting statute, but it's one that's been interpreted as saying you can bring a state law claim for violating federal law, and that's the only basis on which they asked for an injunction. And the issue that was brought up today was whether the issue was even before the court as to whether or not there was a federal right of action for an injunction, which is what the Federal Circuit gave. And if that issue was squarely before the court, because you would only be addressing that issue if the state law cause of action that they brought had been preempted, and that issue hadn't been briefed either. So without getting into many complicated issues, I will say that I can probably boil it down to there's a big fight about whether or not there are additional remedies, and there's also some dispute today from the bench, or some disagreement from the bench, as to whether or not that issue was even ripe in front of the court at this time.
Yep, great. So let me step back and ask a really broad question. So why did the Supreme Court grant cert in this case? Typically, they grant cert in cases that are really narrow, one-issue cases. This is a big issue, a very complex statutory scheme which involves multiple agencies, multiple terms. Why not leave this to the Federal Circuit to figure out, and then if they've worked it out and they're still making errors, then take the case and reverse them, essentially? Why take this case now? Any opinions on that?
Well, and even to add to your point, this was a case in which the Solicitor General opposed cert. The Supreme Court, as you all know, can ask the Solicitor General for its views on when there's a pending cert petition. And there's a very high percentage of cert being granted when the SG agrees that it should be, and there's an extremely low percentage of cases in which cert is granted when the SG doesn't support cert, and the SG is speaking for both the Patent Office and the FDA. So in that sense, it was a surprise. But beyond that, I think most people that I know anyway did think that they would take it because it's a very, very important statute. It's not been construed by the Supreme Court. We look back at Hatch-Waxman, which was enacted, I think, in 1984, and this biosimilar statute is going to be the governing law for decades to come, probably, in a huge, billion-dollar industry, and the Supreme Court was faced with a Federal Circuit that was deeply divided. There were, in the Federal Circuit panel, there were 3 separate opinions written, and there were two of the judges agreed on one issue, and two different judges agreed on another issue. So the panel was very divided. The Federal Circuit declined a petition for en banc review, and I think that there was a sense that there was a need to clarify this statute. The question that was the two questions that were raised were very fundamental. One is this statute mandatory or optional? I mean, people needed to get an answer to that question, and they hadn't gotten a very satisfactory answer from the Federal Circuit, a very clear answer based on this split panel. And the other question about the 180-day notice, at least as it was put to the court by Sandoz, was effectively saying, our biosimilar is going to now be faced with a 12.5-year delay in launching a biosimilar rather than a 12-year delay, which has, certainly profound financial consequences for the industry as well as patient access to biosimilars. And so very, very important questions were raised with, as I said, a very divided Federal Circuit and a statute that needed ultimately to have Supreme Court review. So that's why I think they took it, even in the face of the SG's opposition.
Right, and another relevant fact that came out actually in argument today, the U.S. Solicitor General raised this point that both FDA and the Patent Office have declined to weigh in, have declined to issue regulations that would further clarify the statute themselves. FDA has taken the position that the differences between this statute and Hatch-Waxman, specifically FDA's level of involvement and sort of patent listing, et cetera, mean that FDA won't be sort of setting the framework for this exchange the way it did somewhat involve itself in the Hatch-Waxman framework. So perhaps the court felt that it needed to weigh in earlier, possibly because it wasn't going to get that clarity from on the administrative side.
I also think that the importance of this statute really played a large role in it. This statute has been widely touted as something that's going to be very effective in lowering prices, but it can't be effective if biosimilars can't get approved. And they can't really get approved if they don't understand the procedures and the required processes. Right now, we've only had 5 biosimilars that have been approved since the statute was enacted in 2009. So I think that this will go a long way into spearheading more approvals.
Possible correction. Mike reminds me, I think maybe the SG did support cert here, and I was involved in a different case where they didn't support it. So sorry about that. I think I was wrong on that one. But everything else I said, and I agree with all of these reasons why I think the court thought it was appropriate to grant.
It was interesting, though, because the original petition was filed by Sandoz, who filed a petition taking on the 180 days after licensure point and the injunction point that they were enjoined by the Federal Circuit from launching until that period of time. And Amgen filed what's called a conditional cross appeal, which you don't see granted very often, to Don's point earlier. And it said, we didn't petition for cert, and we don't need the Supreme Court to look at this on its own. But if you take up this other issue of whether, the timing of the 180 days notice and the issue of enforcement of that, then we would also like you to take up the shall means shall issue of whether you need to go through the patent exchange. And the Supreme Court ended up taking them both up together. So it was a conditional cross appeal, which you don't see all that often. But it seemed to me to make, you could be on either side of this table. Half of this table is on one side and half is on the other. As we're seated here, you could be on either side, but I think it probably made sense to take up these fairly interrelated issues together and try to resolve them together once they were doing that, because it's a fair amount of question as to, whether all these aspects are mandatory, and if so, are they only mandatory in the shall means if you feel like it, or are they mandatory in the sense that shall means, there are serious consequences to not doing it.
Right.
Jeffrey?
No, I was just going to respond to a couple of the points that were made, unless
sure.
you have a
No.
formal question. So I did want to point out, to clarify one of Donald's comments, the bio brief was extremely educational for me. I enjoyed reading it very much, so I wanted to congratulate you on that. But I did want to point out that the idea that FDA could license a product before it licensing it, essentially license it without making it effective and allow the 180-day notice to pass before the licensure becomes effective and before the 12 years expire, is extremely dependent on FDA. And there is no provision in this statute, as there is in the Hatch-Waxman, for a tentative approval. So it was our position that that we could not rely on FDA to take that action, and in fact, the agency would probably resist doing so, given that it isn't explicitly a provision of the statute, and therefore Amgen's position would result in this automatic 180-day stay after the 12 years of exclusivity provided in the statute. And with regard to sort of the notice,
Just before we leave that point,
Yeah, sure.
just to comment on that. So, yes, and you're absolutely right. It's not provided in the statute, and that is in contrast to Hatch-Waxman, which specifically provides for FDA tentative approval, where everything, all of the data has been analyzed and then found the product found to be safe and effective, but there is awaiting the time period or what have you. So, or awaiting a patent to expire. So that's true. What we focused on, I think, and is the language in the statute, which does differentiate between approval and approval being made effective. So we thought that the statute, provides a sufficient hook to say that the FDA could do that, and the statute also delegates considerable rulemaking authority to the FDA. I mean, including with respect to what kind of clinical data they need or what trials you have to do. So the FDA has a very, very broad delegation of authority. So it seemed to us that it made sense, and that we thought that they would be likely to do it because I think they're fairly motivated to try to approve biosimilars. But the important thing to know is that none of the biosimilar applications that have come up yet have fallen into that category of FDA considering approval before the expiration of the 12 years. They've all been, because the most commercially successful biologics are ones that have been out there for a while, they all have passed their 12-year data exclusivity period. So we don't really know. I did speak to somebody in the FDA's general counsel's office, I think within the last 3 or 4 weeks, just to find out if there was, just to confirm, has there been any kind of public statement or indication about whether the FDA would do that, because it was explicitly suggested by the Federal Circuit, in the Apotex decision, and she said no, that as far as she knows, there had not been any public position that the FDA had taken so far on that.
And to Don's point, which is a good point, Bio, as he was starting to refer to, is not on an island on that one. The Federal Circuit expressly in Apotex supported the idea of licensure being a prerequisite by pointing out that possibility. So the Federal Circuit has weighed in, at least seen that as a possibility. It's also interesting that I would imagine, but for how it weighs into this argument, as a general matter, most of your members and probably most of the biosimilar companies in the long run would prefer an avenue where the FDA could say, we are approving the product effective 9 months from now, rather than having to wait around for that, so that they could make their adequate preparations and get their things in order. It seems to me to be an interesting position that the biosimilar companies are taking, that they couldn't do that, because I would think in all instances other than for advocating this position, it'd be something that you all would want. Look, statutorily, you can't be on the market in 12 months. I would think that the biosimilar companies, other than for this reason, would prefer that they not have to wait till that 12 years to get the yay or the nay and get it effective some later point in time.
Right. I mean, I think that's true. I think in general, as long as the 12 years stays 12 years, our members would be satisfied by that. But I do think that we get hung up on what we view as the plain language of the statute referring to an applicant.
Sure.
And once you're licensed, the statute in several places mentions to the holder of an approved application rather than an applicant. And I think you can't really, if you're referring to an applicant by nature, you're talking about somebody who's could be somebody who hasn't had an approved a licensed application, and FDA I think would struggle with that as well. As you said, they have not begun to struggle with it, which puts us in a difficult spot because we're coming up on a bunch of potential licensures. And then I did want to say one other thing, just speaking to the practicalities of the issue of notice, and just the idea that the biosimilar company could sort of take take the innovator company or the reference product sponsor by surprise. And just to say that, first of all, there's really no interest on the part of biosimilars in taking somebody, like just showing up on the market with no notice, because launching at risk of an adverse patent decision is an extremely risky proposition. I'm sure you all know, as students of patent law, we're talking about treble damages and coming off the market, the type of damage it could do to your relationships with distributors and customers is significant. And then on the idea that, there is no punishment to not participating in the what's set out in the statute as the exchange of information. We did not opine on this from our client, so I'm speaking purely to my own personal reading of the statute. And my experience as a parent and as a lawyer is that, when you say you shall do this, the question is, or what? And in this case, there is a fairly significant or what, even if in the statute itself, which is that you lose control over the form and the timing of the patent litigation. If there is the exchange of information, there's a lot of winnowing of the patents that can be disputed. There's a lot of efficiencies involved. In this case, it was a relatively unique situation because in advance of filing this application, there had been some public communications by Amgen that there were no remaining patent coverage for the drug. As it turned out, there was a later patent that came into play, but Sandoz presumably could have believed that there was no reason to go through this informational process, which can last up to 8 months and be quite costly, but rather would just go ahead and say, no, we're not going to participate in it. It isn't relevant here. The end result is always patent litigation. Let's do the patent litigation, even though we lose the ability to control and narrow it by failing to go through this process. So the idea that that there's no payment in general on the part of biosimilar companies, I would say is not quite reflective of what is reflected in the statute. Although, as I said, we did not take a position on whether there was some other injunctive type relief under state law or federal law in our brief.
This issue, it might be worth commenting. The issue of could the FDA give approval prior to the expiration of the 12 years came up in the argument today, and at least by my notes, I would say that Justice Kennedy, Justice Breyer, Justice Roberts all made comments that suggested that they were quite open to that proposition.
To that point, the statute is pretty deferential to FDA and does give FDA room to make further regulations. They also could invoke a before period, where a before clause where they say notice can't be given before a certain date. And in the Hatch-Waxman regulations, FDA puts in a lot of regulations about when Orange Book listings need to be submitted, and they created kind of an extensive program through implementation of regulations. We're only 8 years out of the statute. FDA took 12 years to make MMA regulations. I'm not saying that FDA will, given from the transcript, it seems like FDA doesn't really want to get involved here, but there is always that option if the court does go by the plain text argument that refers to the applicant. I know there are two sets of plain text arguments, so I don't want to narrow myself, but are specifically the one that we articulated, which is that the applicant should be the one should be giving notice rather than a licensed product.
Right. And several of the justices seem to be just begging for the agency to do something here so that they did not have to decide this in the first instance. I think Gorsuch was notably silent on that point. Of course, we didn't hear anything from Scalia.
Right. No, I thought that was quite amusing because Justice Breyer very early on in the argument said, why shouldn't we just leave this to the FDA? Right. And, and he's somebody who's very supportive of of agency deference and all that. And as we all know from all the reports on Justice Gorsuch, he has quite a different view about that. So I almost wondered whether Justice Breyer was trying to engage Justice Gorsuch on that issue.
Yeah, so we began talking about what happened today at the argument. Are there any, Michael mentioned the takeaways he took from the argument today. Anything you were surprised about, the justices talked about, failed to engage with? Anything that sparked your interest from the argument today?
Well, we had AbbVie's brief, this is a matter of public record, our brief had advocated this idea that the remedy issue wasn't really truly and squarely in front of the court because, as I'd mentioned earlier, these were state law causes of action, and the issues that were being discussed about whether or not there was a federal right to an injunction, therefore, weren't squarely before the court. We didn't know if that would get much playing time, but it turns into a question of preemption, and it got, I would say, solid 20% of the argument was about whether it was the right vehicle and whether or not the argument had been made that the state law claims, which is what it was all about, were preempted by the federal statute, and therefore that you'd be limited to federal claims. So I was a little surprised and happy about that, based on the position that we had taken. I guess I wasn't surprised that it's a very, obviously it's a very, Supreme Court justices are superb at what they do, but they do things other than IP law, other than like myself. And they also do, it's the first time they've wrestled with the statute. So it's a very complex statute, and I felt like there was, and rightly so, a fair amount of tutorial in addition to argument going on today.
Yeah.
And that's understandable, but, understanding how the statute works, I do predominantly pharmaceutical and life science work. Our client that we wrote the amicus on for AbbVie, Humira is the best-selling product in the world, and we do a lot of that work. So I've spent a lot of time studying the statute, and it's easy to go in forgetting that other people may not have spent thousands of hours trying to decipher the nuances between Section 9 and, the K section and all that type of different thing.
But they're the important people.
Yeah, right, but they're the important people. That said, they're very, very smart people, and they're aided by able clerks. But there was a fair amount of tutorial before there was, I think, pure advocacy going on for a little while. So,
Yeah, I think that they were troubled by the California state law aspect of it. Here's a very intricately crafted federal procedure, and the idea that state laws, and perhaps different state laws in different jurisdictions, were going to dictate what parties could do under this statute was very troubling for them, and I think that they kind of wished that the preemption issue had been argued, because I think they might have come out finding preemption. But the result of that was that there was not a whole lot of discussion really about whether an injunction is appropriate under federal law, because it wasn't really before them. Bio took the position that, of course it is, that if you're in front of a federal court and you're dealing with a federal statute and somebody's not complying with it, then the court has, inherent equitable power to enforce provisions in the statute and has inherent equitable power to grant injunctions. And injunctions are provided for under Section 281 as well. So, and there's the All Writs Act, and so it'd be kind of crazy in a way to say that there are these provisions, if you assume that the court decides that they are mandatory, that the information exchange is mandatory, and then to say that nobody can require it or enforce it. And it's not a situation where you have a government agency that's charged with enforcing the statute and you're wondering whether private parties should also be enabled to enforce it. So there'd be essentially nobody who could enforce it. And I think that Amgen made a pretty good point in that if the remedy is just that you can bring a declaratory judgment action, that doesn't remedy the harm. I mean, these provisions were certain provisions, such as the information exchange, the provision of the application was for the benefit of the sponsor. And if all they're relegated to is bringing a declaratory judgment action with no information about the product on which they're trying to sue for patent infringement, that doesn't really remedy the harm. And it would be very peculiar to say that's the exclusive remedy and a court can't do anything, except the court can grant all kinds of, discovery can enter discovery orders in which it can compel production of the same application. So, why couldn't a court do it, really? But it was that'd be the biggest surprise to me, I guess, too, that as much time was spent on talking about remedies and possible preemption of state law as opposed to the substance of the two issues that you identified at the beginning.
Yeah, I mean, I was definitely surprised about and especially about the focus on state law and preemption. And I unfortunately was not able to attend the argument, so I'm not sure whether they focused on sort of the how California law is also a little unique in this respect too. So under another state's law, this might not be actionable at all. So it would create a lot of disparity if the states were left to be the ones to do this. Again, in our brief, we didn't take a position on this issue, but I will say it is, the idea of sort of flying blind and sort of the statute requiring this exchange of information, and otherwise the sponsor is left in a difficult position. And it is, I do just want to contrast it with Hatch-Waxman, where because the biosimilar applicant is also flying blind a little bit here, because unlike under Hatch-Waxman, there's no requirement to sort of affirmatively list on the part of the reference product all of the patents that you believe apply to the processes and molecule, so that there's some sort of a frame of reference. The purple book, which was what was going to cover biologics, really has not been used in that way, and it isn't provided for in the statute. So there is a sort of mutual difficulty, mutual lack of information here that is addressed through this exchange of information. So both parties suffer to some extent if you don't go through the process. And so there is, despite, even if it is the declaratory judgment action that happens and it ends up being through discovery, that's a difficult result for both sides in a traditional case. This case, again, was an unusual one because of the situation that how it came forward for both parties.
Yeah, so last 10 minutes, let me turn it over to you guys. Ask if you have any questions about this incredibly complex statutory scheme. Yep, right here in the front.
I'm not going to ask who you think is going to win, but I noticed in attending the oral argument that it reminded me of my moot court days, in which I think Ms. Maynard got about 3 sentences out, and then she barely got more than that throughout the entire time. Well, Seth Waxman for Amgen was speaking in paragraphs.
Yeah.
Does that mean anything?
Well, and the irony was, if you were at the argument, you'll know that the irony was Seth, who's an excellent advocate, he got up and said a sentence or so and then said, but rather than me try to shove information on you, I'm interested in what the court's questions are. And so the irony was he was opening himself up. He affirmatively says, hit me with your best stuff, yet he got lengthy periods of time to just talk about his position. So it was interesting. When he started out that way, I didn't know if it would just be a barrage of questions.
I think that I think Deanne Maynard had the tougher argument, number one, and she led off. So an awful lot of time, I thought, was, well, I hate to say wasted, but was spent on asking very basic questions about what's in the statute and what the how many days do you have to wait to do this, or what does it say, or what comes next, or whatever. So she got all of that whole barrage of questions that were just, I think, the justices trying to get themselves to dig into the statute a little bit. But I wouldn't make very much of her getting more questions than Seth Waxman, really.
And I think the complexity of the issue or the issues here, is one that necessitates a heavy reliance on all of the written briefs, especially considering the textual argument. I'm as you can see from my kind of mumbled intro, it's kind of it's tough to conceptualize this without the statute directly in front of you. So I agree that I don't think I would put too much stock in the questioning and too much stock in the actual oral arguments themselves. I think the briefing here is going to be incredibly important, and particularly the Solicitor General's brief will be pretty important, as well as obviously the parties' briefs, and hopefully our briefs will help make the
I think the
decision,
amicus
but-
briefs will hopefully make a difference in this case, because the court's looking at what effects is a ruling we make going to have on the industry, and the only way they can get that information, they think, is through amicus briefs. So I think you can't read into that what's going on, who's asking what questions, like you can in some cases, because here there was just a barrage of questions that were basically said, wait, explain this to me again. And by the time Seth Waxman got up, I think those questions were done.
Some of those were done.
And some of those of us with grayer hairs in the room already know this, but for some of the students who are here or listening, number of times you come out of an argument and say nailed it, and then turns out that
Yes.
the questions were not leading in the direction, or the vice versa, that you thought you had a tough day and
Yeah.
it worked out all right. As for those of us who've done it for a couple of years know that it's sometimes very hard to read tea leaves.
Yep.
You know, I will say Deanne Maynard, of course, got the last word in, got to do rebuttal, and she had 3 minutes of rebuttal, and I would compliment her. I thought she did a terrific job. And there were no questions then, so she got like 3 minutes of bang, 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 her best points. But, you know, in terms of outcome, I think one of the things that perhaps, one thing that could happen that maybe some of us didn't think that much about, but it was sort of voiced by Justice Breyer. So they could well decide that they want to say, here's what we think the statute means, but we're not going to deal with the remedy, and we're going to remand it to the Federal Circuit, because the Federal Circuit, for example, on the, you know, is the provision of the application required, because the Federal Circuit decided it wasn't required. They didn't really have to deal with the question of can you compel it under the statute. And they were dealing with the state law claims, but then they said those were moot because they'd already decided that you didn't have to comply with the statute. So, you know, this court could decide that it doesn't really want to get into the minutia of how to enforce this statute and just make some judgments about what these two first issues, what the statute means.
Other questions, Eric?
So, I believe there's some manufacturers or biologic manufacturers that both represent the innovator and the biosimilar. So,
Including Amgen, actually.
There may be some in this room.
so I mean, could you see there being any reason why then the biosimilar would want to actually have their application or submit their application earlier, or have the actual innovator not receive the information until later on, you know, at the 12-month or after? Like kind of the opposite of what their stance would be for the issues themselves.
What I will tell you is that I think that, like any good company would do, that companies that are working in terms of both aspects need to balance those things and need to probably keep in mind at the end of the day what their goals and objectives are. You know, there's some aspect of some certainty, no matter how this all plays out, will benefit everybody to some degree anyway. I mean, we all have our wants and our desires and the things that we don't want, but having a level of guidance in terms of what we do will have its own benefit to be in some degree of certainty. But you know, I know companies struggle with that. Amgen is excellent counsel, and they were representing the innovator today. And in a case I have against them on Humira, they're representing the biosimilar company. They're well represented in the cases, but you know, the positions that they take on one side of the aisle can impact how things are viewed in the other case. So it's like any organization, you need to make your choices.
I will say there was a complaint recently, I think it was also Amgen, who made the complete opposite argument that the whole patent dance part isn't required. They were the biosimilar in that case, and the other side and you like just taking parts of their complaint in this case from the lower court and just mimicking it right there. So there is a lot of that consideration.
I will say that going back to the development of this legislation, back then, it was really not the idea that the innovator companies like Amgen, would become biosimilar manufacturers was really not out there. And I will say that Amgen was probably among the most aggressive of the innovator companies in terms of what they wanted out of this statute. Because it was a very, at that time, the folks on the other side of the aisle were the the generics companies, and you just couldn't imagine that Amgen or Biogen is another one now that has gotten involved with biosimilars, would ever be on the biosimilar side. So what has happened, as I think companies like Amgen have realized, that it takes a lot of expertise to manufacture biosimilars, a lot of resources, and they have the capacity and the skill to do that, so why not do it? And as that sort of business model has changed, I think we actually have seen Amgen's position, for example, modulating. And I thought when they didn't initially petition for cert after the Federal Circuit decision on question 1 of, does shall mean shall, I kind of thought, well, maybe they're thinking they're going to be on the other side of that issue, and maybe it's not a terrible thing. So I think we've seen a real evolution in the business model as more and more innovator companies have decided that they want to manufacture biosimilars as well.
And this is not necessarily a sort of like company position thing, but our clients took the position, at least on the sort of like the additional 6 months of exclusivity there, that it really didn't have to be, it wasn't a zero-sum game, and that essentially lowered prices for biologics, which I think everyone on this panel will agree that biologics are great and that they have improved healthcare in this country, and that we want more patients to be able to access biologics and biosimilars, but and that sometimes a lowered price for a biologic or a biosimilar will expand the use of that product and actually just expand the market, make it a bigger pie for everyone, as opposed to trying to divide up a same-sized pie. So there is also that consideration in there. We tried to get that in our briefing and hope the court will consider it.
Yeah, so one of the greatest things you'll find when you work at a firm or in-house is deciding these kind of questions. How does an argument I make in one case impact what I'm going to do, the business model, in another case? Because that's the bigger question. I mean, winning an individual case might be a game changer, but probably not. What you always want is not to affect your business model with an argument you make in one case. Jim?
Well, the court has wrinkled its nose at the lack of regulations over the Orange Book. It sounds like they may do that again, or at least somebody may do it again. Are there areas where the various parts of the industry could agree that the FDA should be doing more, writing more rules? And after a decision comes out here, will the Supreme Court leave room for useful rules to be written?
They'd have to both, leave room and then also provide resources to FDA to do that. I mean, FDA, I think, would take the position that it doesn't really have the capacity and expertise to involve itself too deeply.
To write rules on whether shall means shall?
Oh. Right. Well, they've taken the position now that they're not going to do that, right? I mean,
right. But would the industry agree that they should?
So we actually at Hyman Phelps work very closely with lots of different participants in different parts of the industry. And I would say that on a whole, industry always wants FDA to do more and FDA to make more regulations or put more guidance documents out so that they have more of an understanding of what FDA's actual thinking is. The common adage is that more more is worse because it hinders your business, your ability to do business. But the reality is that it makes things a lot more clear, especially from the innovation perspective. So I obviously can't speak on behalf of our clients, but in our experience, clients want more guidance, want more from FDA. That said, it's really, really challenging to get FDA to come to consensus and figure out something that's going to help both sides of industry, especially when it comes to things like the Orange Book and you've got to satisfy the generics versus the brand companies. It's very difficult to do something that everybody doesn't hate. And that's really where they end up a lot of the time, where everybody's kind of mad about everything. But to that end, again, FDA doesn't have the resources to put this time and energy into all of this. And I think that their experience with the Orange Book has been so awful that they just don't want to be involved anymore. Have you ever tried to get FDA to respond to questions about the Orange Book or talk to you kind of about procedural issues around the Orange Book? It's like pulling teeth. They hate it. So I think that they would like to just stay out of it as much as industry would like to have more guidance.
So I was going to add that I agree that FDA lacks resources, and I think it has been a source of frustration. If you think about it, what they have done, they haven't done any rulemaking as such under the BPCIA. They have issued draft guidances for comments, and they've sometimes turned those into final guidances. I think some of them are still draft, years later. And, so a lot of the fact that we only have 5 biosimilars approved in 2017 and the statute was enacted in 2010 is really because of the lack of clarity. Companies didn't really know what kind of data package they were going to have to submit. We only this year got guidance on interchangeability. So it's kind of the lack of guidance that has slowed this industry down, I would say. But as far as rulemaking on, does shall mean shall, remember that the statute has 2 sections. It has Section K and Section L. Section K is about the whole FDA approval process for biosimilars. That makes a lot of sense for the FDA to be providing guidance. But Section L is a patent dispute resolution provision. The FDA doesn't have any particular expertise in patent law or in litigation. And so it doesn't make that much sense for them to interpret that language. One of the problems and one of the reasons the statute is as ambiguous as it is that it was developed completely by the health policy specialists in Senator Kennedy's office. It did not go through the Judiciary Committee. And so the people who were experienced and knowledgeable about patent disputes and patent litigation and all were not actually involved within the congressional staffs who worked on this bill. And so the lawyers like me who got involved with it were kind of appalled at the way it was written. But, we're talking to people whose specialty is health. And so their interest was much more in Section K than Section L, really.
Great. So with that, please join me in thanking our panel. And after, we're going to have a reception outside, so get your drink on, get your food on, so enjoy. Thanks, Jennifer.
Yeah, it was fun.
Thank you.
Are you guys based here in DC?
Yes.
Oh, great. So you're just around the corner then?
I literally live 3 blocks away.
Really? I do too.
Where do you?
I live on 44th and
I'm on the opposite direction. I'm a Reno and Yuma.
thank you.
Right by the Sheridan School.
Compatible with ours, they're much more focused on the revenues. So we didn't.
We thought we could add a little bit.
I think, like my
Sandoz
We
is
do our nanny share like across the street. Right across from
everyone
nanny.
is always
So we're right here.
give notice immediately upon marketing that. And of course, we could point out in our
Mine
case, they got
too.
notice, they got got licensed
Yeah.
last year. And
Thank
no one
you.
has.
Great. Ours is
Or that
ending
everyone's
in
going to follow the
February.
patent dance, but here are all the examples what they haven't. So
It's tough, especially when you've had two, because then the other people.
Well, I had,
Well, what are you
because
doing
of my
with your other kid doesn't have
early
school?
involvement, I was
It's
sort of
tough.
passionate about the whole
Thank
legislative
you for
history,
having us.
which I know doesn't go down
Sorry,
that
I
well
fumbled
in
my
the Supreme
opening.
Court, but I mean, there's just no question. I mean, there are all these
Thank you.
bills out there that would make the whole thing
Yeah.
optional. It's what the generics company wanted. Companies wanted, and, you know.
Part of it is next year,
Many
but
of
there's so
my-
many patent kids.
anyone even playing devil's advocate that if there's
Oh, yeah,
no
that's a
remedy
lot.
other than the
Yeah.
ability to
And the
file a
guy that
DJ.
teaches copyright here, he's
Yeah,
No.
well,
Oh, really?
maybe it is for
Yeah,
early
that's tough.
information exchange you could argue about, but how is it a remedy for
So Max is
licensure
here.
without notice,
Yeah,
blowing off
yeah,
the notice?
of course.
Because at that point in
My
time, you can
2-year-old.
sue anyway.
It's already on the market. I mean,
You know, my husband
no,
came
it's-
with
that's-
me.
I've never figured that one out.
because you can't fail.
Yes.
Until you
Yes, I do want to see that.
Nowadays it's subsumed within the EPA.
Yeah, nice to meet you as well.
Nice meeting you.
Nice meeting you as well.
Nice to meet you. Me too.
It was nice to meet you.
Really nice to meet you. Thanks so
Yeah,
much.
Thanks for coming.
Really appreciate
Took me a
it.
little bit to warm
Yeah.
up, but I
Yeah, it was very nice to meet you. You know, thanks for helping keep lawyers employed for years and years in this legislature.
No doubt about that. I do a lot of